Okay, I think great. We have some of our participants here and the rest will keep joining. So good afternoon, everyone. Today we bring to you another webinar from the Center of Constitution and Public Policy at the University of Institute of Legal Studies at Punjab University. We have 5 panelists today here with us at this Zoom platform. I would like to introduce everyone. I will start with Professor Dr. Manoj Sinha, who is the director of the Indian Law Institute, one of the most prestigious, or if I may say, the most prestigious academic institute in India, based in New Delhi. Professor Sinha has been he has so many accolades under his belt that I do not know where to start, but I will list some of them. His specialization is in human rights, constitutional law, international humanitarian and refugee law, criminal law, so many areas. And he has published extensively and has spoken at so many different platforms. He has been the former director of the Indian Society of International Law in New Delhi. He also had the prestigious visiting professorship at Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden. He has taught at the West Bengal National University of Juridical Sciences. He has authored, edited, co-edited numerous books, and I cannot list them all here, which will justify his contribution to the legal academic field. Thank you, sir, for being with us and for honoring us with your presence today.
Thank you very much.
Next we have is Kevin W. Gray, PhD. He is currently a JD candidate at Osgood Hall Law School in Toronto, in Canada. He is presently adjunct professor, Humber College, Toronto. He has researched at the International Residual Mechanism for Criminal Tribunals at The Hague. He has also served as the assistant professor at American University of Sharjah, UAE. He has taught philosophy, various aspects of the discipline of philosophy, the Klaipeda University, the American University of Afghanistan, Bard College in New York, and many other places where he has exhibited his legal, academic, political, science, philosopher skills, which encompass such a wide range of subjects. Dr. Kevin Gray, welcome on this platform. And again, an absolute honor to have you with us today.
Thank you, Dr. Bedi.
He will be talking about the impact of COVID on the rights pertaining to the European Court of Human Rights in Europe. And that is a perspective we all are waiting to hear. Professor Sinha will be talking about the international aspect and the impact internationally. We then have Sebastian Lafrance, who is the Prosecutor Crown Counsel for the Public Prosecution Service of Canada. He is also a part-time professor at the University of Ottawa in Canada. He has clerked at the Honorable Mary Deschamps of Supreme Court of Canada. I'm sorry if I pronounce it wrongly, but I'm not as good with language as you are, Sebastian, because he is a polyglot and he knows only 25 languages, if I may so. He has lectured in 17 countries and has published extensively. We welcome you, Sebastian Lafrance, to this platform, and he will be talking about the impact on the fundamental rights in Canada during this time of COVID. Finally, we have our director of the University Institute of Legal Studies, Punjab University, Professor Ratan Singh, who has provided exemplary leadership during this time. So that is one impact a positive impact of COVID, where we have been able to function probably in a manner which laid the foundation for the other institutes in Punjab University. Professor Ratan Singh's knowledge in constitutional law will be another contribution to this platform to discuss the aspect of rights which are in contention because of the impact of COVID. Professor Ratan Singh, welcome. And I would also request you, being a host uh, as well, I would request you to welcome our guests and also introduce the theme for today's webinar. Professor Ratan Singh.
Yeah. Thank you, Professor Shruti Bedi. My dear friend and very senior colleague of mine, Professor Manoj Kumar Sinha, is the director of Indian Law Institute, Delhi. Mr. Kevin W. Gray and Mr. Sebastian Friends and Professor Shruti Bedi. Well, the topic which you have framed for deliberations, for discussion. Really, this is a topic for the day, and there is a need to deliberate, to discuss, and to debate over all the things. And for this, the resource person which you have invited are from national and from the international aspect, from the different constitutions also. And I'm very sure the deliberations will be very, very fruitful. And we will definitely reach to some of the concluding remarks that where we are going, what we are doing, and what we need to do. But before you start with the deliberation, let me put my nose into the discussion. Like we all are living in the civilized society. Once we are living in the civilized society, certainly we always expect about civilized state. And the civilized states to make the civilized nation. Certainly, as far as the different laws are concerned, it may be written or unwritten, we have the right to participate into the governing system. That is why we elect the people, we elect the parliamentarians, we elect the legislators, they make the policies for us. It's just a MOU which we enter into with the parliamentarians. As with reference to our preamble of the Indian Constitution, which speaks about we the people of India. Because we the people of India bow our head and we give everything, we submit ourselves to the Constitution. And those who are framing the laws, who are the legislators, they are to protect our rights, like our Constitution provides about justice, social, economic, political. So we are expecting all the things that our justice is to be protected. Friends, it is not just only about the Indian Constitution. If I go with any of the national, regional, or international covenants, conventions, treaties, or any of the documents, all speaks about justice, all speaks about laws regarding humanity, all speaks about human rights. And whenever any of the document was signed, any of the document was created at national level or international level or the regional level, India is always one of the country which always stand by regarding the protection of the human rights. But with this COVID-19, as far as the impact is concerned on human rights or on fundamental rights or on any of the statutory rights, and we have a long list of legislations, we have a long list of policies which are framed by the government for our protection. Like for instance, in India, we have National Disaster Management Act. Now the question is, the basic purpose of this law is to prepare that if in case there is a national disaster, that how to manage the affairs of such a disaster. There are economic affairs, there are political affairs, there are geographical affairs, there are psychological affairs, there are issues of health. Everything is to be managed. No, once law is there, we have economic resources, we have the political will also. But friends, just pain me. My eyes filled up with the tears when I see right from morning to the end of the day what is happening, especially to the one marginalized class, that is only labor class, migrant labor, as far as specifically to India. Because reason being, this is what I feel is the largest lockdown of the world. And in this largest lockdown of the world, there is too much suspension of the human rights. The human rights jurisprudence has taken its different shades and shapes and colors also. Because reason being, when we talk about human rights, and during this period of just 2 months, what is happening? The people, they are shuttered like anything. They do not have any right to life. They do not have right to health. They do not have any right to move. They do not have livelihood. They do not get the proper food also. And there is too much violence. When we talk over about right to food, we understand, we have seen the news right from morning to evening, the people are dying for just one piece of bread. The people are fighting, they are snatching, because reason being, this is the law, this is the state where we are living as in a civilized society, and the civilized state is to manage all the affairs. But the question is where the right is there, that if a person cannot get a minimum survivalship, he cannot get food to eat, at least not 3 times, at least one time, at least he can survive his minimum survivalship. And as far as right to health is concerned, we all understand. You just see the positions of the hospitals, see the position of the health workers, see the position of those who are warriors of this coronavirus. Because reason being, even health care is not much taken care of those things. And during this period, we understand that we have right to movement, we have right to privacy, we have right to information as far as the human rights are concerned. But during this lockdown, all these rights are shattered. I don't know where they have gone and where the legislations of respective countries has gone. And on the other side, in some of the states, the behavior of the police. In some of the states, okay, the behavior of the police is okay, fine. But in many of the states, this the brutal behavior the police has adopted as far as managing the affairs of this virus. Now, the question is, when I have seen a herd of people, I don't say a group of people, I say herd of people, when they were disinfected, like when a group was gathered to in a particular place, and they were sprayed, like they were disinfected in a group, like that they were disinfecting to the buffaloes and cows. So that is the pride of this. And friends, once the migrant labor was moving from one place to another place, because reasonably no time was given to them, at least they can move to their respective places. No time was given to them, and the people, they feel like to go back to home, because there was a one perception that we are to die. If we will stay here in the respective places, we will die without food. And if we'll go there, quite possible there are chances that we can be saved. So they all started to move back to their respective places. And once they are moving back to their respective places, and they have traveled, I mean, more than 1,000 kilometers by foot they are traveling, by rickshaw they are traveling, by cycle they are traveling, and along with them, their children, the child of 18 months, a child of 4 years, a child of 7 years, and an older lady of 80 years is traveling, is moving, is walking in the midnight. And what is happening there? During the midnight, once they are taking the ride from someone, they're taking the airport, someone, nobody is giving any food. And during this journey period, many accidents took place. Many people died during the journey. And if you just see the morning, we had a news that 24 persons died in a clash of two trucks. And those who are the labor was moving. Because reason everybody want to rush back to the home. And there was about 16 people died when they were sleeping on the railway track, and passenger goods train, it crushed them like anything. So not only these are some of the examples which we have in front of us, but 100 examples are like these. I've seen a man was riding a cycle along with the wife and a child of 4 years and 18 months. Just said with an accident by a car, this man and the wife died. And this child of 18 months and 4 years, they survive. And now the question is, what is their survivalship? Who will take care about their rights? Who will take care about their future? So issues are like this, and really it's a very, very painful, and what is happening in probably in all the states, and particularly I'm talking about India and some of the neighboring countries also to India. And during this period, what happened, as far as once the migrant labor was moving, and along with this migrant labor, there were the female, those who are in a family way, the pregnant. The news is there, the lady, she was pregnant, and on the way when she was working, she delivered the child. And after taking a rest of 2 hours, again she moved 150 kilometers after giving a birth to a child on the road in the midnight. It's not a one case, there are many cases like this. And during this, again, about child abuse, domestic violence, gang rape, it happens. So many reports has came into existence for this purpose. Now the question is, apart from this domestic offenses, which has probably in some of the NGOs has conducted a survey, and over this they have established that this rate of the domestic violence has been increased because reason being state is shut out, their houses are shut out, even the streets are shut out, and they are not moving out. It means there is a psychological depression, there is a psychological disturbance, and during to the psychological depression and the disturbance, the people are fighting at home also. May it be a domestic violence, may it be a crime, or maybe whatever the action is, but some type of violent activities are there. And even the activities like the child is abused. We have heard the news also, a child is abused by the stepfather, a child is raped by the stepfather also. So during this period, such type of things are happening. And the next comes about right to privacy. There is no any question of right to privacy, because reason being, in some of the ways, if a person is suffering from a virus, now the question is whether the news about this gentleman is to be given, it to be spreaded out or not. These are some of the issues. No doubt our judiciary has played a very much important role, but to the extent to which we were expecting, probably not. I say no. Being a student of law, I say no. Because the morning Supreme Court has given a judgment that we cannot control the movement of the labor. At least they cannot control the movement of the labor. They should have given the directions to the state government. They should have given the directions to the administration that they are to they are to manage the affairs accordingly, but they have not given the direction. So friends, it's not a question about when we're talking about social distancing. I say we should be very close socially. We should be very close socially. Then only the problem of violation of the human rights can be resolved. The problem of such type of psychological depression can be resolved. We should be socially close, not at distance. We should be, if distance, that is physical distance, not social distance. So probably the term should be physical distance rather than the social distance. So what I feel is, with reference to this violation of the human rights, it affected to not a particular class, not a particular sex, it's not particular group. Probably it affected to the humanity at large. Convert me, it's a region, it's a country, it's a one local area, it's an international affair. Convert me, it's an Asian country or it's a European country. This is affected human beings. And the rights of the human being are virtually violated in such a way. And there is need that this, when I started my talk, probably I used the word civilized society. We have to organize ourselves into the civilized society so that we can keep it up and we can protect, promote, and preserve the human rights. So I welcome to all the speakers, and I'm very sure that discussion will be very fruitful, and we will at the end of this will definitely reach the concluding remark. Thank you very much, and welcome on this platform, please.
Thank you.
Thank you, Professor Ratan Singh, for an insight into what aspect of the problems that we are facing in India. And in fact, the United Nations Secretary General, Antonio Guterres, has issued a warning that this pandemic must not be used as a pretext to trample over individual human rights. And he, in fact, said that what started as a public health emergency has rapidly turned into a human rights crisis. And here is what, when I would like to ask and request Professor Manoj Kumar Sinha to come into the picture and express his views on the impact on the rights in the international arena. Professor Manoj Sinha. Arpit, could you unmute Professor Sinha?
Thank you,
Yeah.
Professor Shruti. First, for inviting me for this wonderful seminar, webinar basically. And also thanks to Professor Ratan Singh, a good friend of mine, Kevin and Sebastian, for joining us from far away to share our view, and uh, eagerly waiting to hear about the how European Court of Human Rights will address this issue. After hearing Professor Ratan Singh, which has been bothering all of us for last couple of days, we are very much concerned. And just Shruti ended with that what happened in entire process as Secretary General of the United Nations has mentioned that in context of right to health, it seems that human rights have been trampled by the or excesses of violation of human rights has been taken place in many countries or many states. It takes me very close to the Karl Marx and Karl Marx when it's in Communist Manifesto. So some of the scholars, when they are talking about the cosmopolitans, and they examine how Karl Marx view the cosmopolitan. Cosmopolitan means whether world can be truly globalized and individual can become the citizens of the world. In that context, what he in Communist Manifesto, he said there is a possibility of cosmopolitan. The world will become one. We all can become citizens of the world in a true sense. And that is possible when he said in his Communist Manifesto, proletarians of the world unite. Proletarians of the world unite. So he focused on that particular. And I see the problem of the poor. So we are locked down. So we are fortunate. We are sitting in our home and just watching on the TV what is happening and feel very helpless that we can't do anything. We feel very sad. And I'm shocked. It's not this is also a time where number of states are from different political parties, but there is a common trait. All have deep sense of insensitivity. They're not bothered. They're not at all thinking about. When you see package, lot of packages, I don't want to see that packages. I feel so disturbed. Package has no meaning. What you are directly, it requires direct action. It requires direct attention. Poor people who's going on the street has no idea whether railway station or something. And this has to have this has started from 22nd March, and it's going on in the first, first you stop, you proclaim that you have sufficient number of food, lot of things are there. And today we find, as Professor Ratan Singh has mentioned, many people are hungry, many people have no money. Even if train is there, they don't want to go by train because they don't have money, how to board in the train. And so a lot of issues, a lot of challenges are there, and we feel the right to life with dignity, right to life with privacy, right to life to travel from one place to another. All are keep on violated, or violation of these rights have been taking place every day, and particularly for the weaker sections of the society, vulnerable sections of the society, women and children. A large number of human rights have been violated. But today we are here to discuss about more on the, so this is the challenge which I feel, and particularly the challenges are big and huge when we talk about the developing nations. Like even India, we proclaim that we are very developed, but today we are really exposed. Today we are really exposed at what kind of development when we can't take care of our more than 60% of populations who lives in the village, who came all the way from the different parts of the countries to build the big cities. So wherever we are in apartment and big houses, mall, build whatever, but we fail to take care of them. But I hope that things change. and it will improve. Come to the second point which we have. So we live in a world, and in general understanding, when we talk about the right to health in the international perspective, so what we believe right to health is largely is a individual states. So we feel that like even international law primarily focuses that it's a individual states are responsible for. So individual states are responsible for preserving public health in their territory. So states has a primary responsibility to take care of the health of their own citizens, no doubt about that. However, in some situation, in some situation, their efforts may be rendered meaningless without international cooperation. So so what we are today, so some even effort we do, but some kind of international cooperation is needed. So what we have to search, so we have this one, so we have reached on the pandemic. Pandemic means worldwide. It has affected almost all states, and today we have around, soon maybe in a day or two, we'll have around 5 million people affected by the coronavirus, and around 3 lakh people is going to die soon. And similarly, in India, 88,000, 85,000 already affected, and around 3,000 people going to die soon. So we see situation has been like, getting worse day by day, and it's a big challenge for all of. So we all have to look into collectively. What I plan to do in my presentation, then I'll make in three ways. That first, we'll try to see the WHO. The second, on the United Nations, and third, briefly, in the international human rights regime, what it talks about the international human rights regime, and what are the obligation a state has regarding the implementation of international treaty, specifically dealing with the right to health issue. I leave the constitution. Constitution we have in the directive principle of state policy 39E and 47, and then of course Article 21 has been also used in the Indian scenario. We have a strong jurisprudence. Maybe other speakers will throw some light on the constitutional part as well. So when we start with the WHO, so we have seen the WHO, particularly we have speakers from Canada, and we see how Trump has reacted regarding the role of the WHO in entire crisis. As you are aware, WHO reaction was, so it created some kind of doubt, ambiguity. We don't know. I don't want to judge functioning of WHO, but there are sufficient reasons to think about whether WHO try to delay or try to hide something, or or support the China. These are the subject of investigation, which may be one day proof right or wrong. But WHO, so the first thing, which is a WHO constitution. WHO constitution talks about all member states have to cooperate. That all member states have to cooperate in situation of pandemic, or also in the epidemic. The members of the state has to all states have to cooperate. The another important, which is in this particular context, is the international health regulations. International health regulation and Article 6. Article 6, which is very important, which says that the state has to notify if such kind of pandemic or some kind of infectious diseases it started taking place in a particular state. They have an obligation to notify the WHO, and WHO, after doing necessary examination, can make a declaration, or can inform the world, like public health emergency of international concern, public health emergency of international concern, and to world to this is the international concern, and we have to work together under the Article 6 of the international health regulation. And this happened in this particular crisis. This happened also WHO on the 30th January 2020. It has notified, it has announced that public health emergency of international concern according to the Article 6 regulations they have mentioned, and bracketed it is extraordinary event. Perfectly fine. But locking down or declaring pandemic, it was little bit late. So WHO finally declared pandemic on the 11th March 2020. 11th March 2020. Some of you may be aware, and we all are aware that Italy was the first country to declare nationwide lockdown. Italy was the first country, and Italy declared on 9th March 2020 nationwide lockdown. China has done in earlier, but China has not nationwide. So nationwide, first country Italy. So you see that even WTO, WHO came later after 2 days of declaration, the first nationwide declaration of the pandemic by the nationwide lockdown by the Italy. Then there was a response from the WHO that it's a serious and the pandemic they have declared. So there's some way they delayed the entire exercise, and what we see the reasons which makes us critical of functioning of WHO. Not it's up to the marks which we all expect, which all individuals, states expect. It has failed, and that largely there are 4 points I have. The first, which I say, it seems. So I'll just add is it seems WHO overtly China centric in this particular crisis. China centric is view or something. Second, and that led to the proper coordination of necessary equipment like PPE, that personal protection equipment, medical kits, testing kits, and other medical facilities. Because the large number of states, they depend on the help. Even we today in the early morning, I saw in the Times of India, US President has promised that they are going to send the ventilator to government of India. And other day, our honorable Prime Minister had also said the day we have declared, we did not have sufficient mask or something, but today we are capable to produce and also we can export. So that is a great achievement on the national level. So in number of countries, they depend support from the testing of medical kits, personal protection equipment, and other medical facilities from WHO and other countries. You cannot think in Africa, there are a number of countries, they don't have ventilator, 1 or 2 ventilators. There are ICU is not there, which has been told to me. So surprisingly, number of African countries heavily depends from the World Organization, some kind of support and assistance is there. The third is it also delayed its reluctance to ban international travel. So internal, it's somehow WHO also delayed in the recommending ban on international travel. And the last point which I've said, also declares, it did not declare the public emergency of international health concern. So that these are the reasons which we feel WHO, but I leave out that WHO part. Then we come to the second stage, which I'll try to see, because I have said in the beginning, primarily it's its state responsibility to take care of the health of its citizen, but in some cases, international cooperation is required. And this case definitely falls on that category where we need some kind of support from the international community, international organization, regional organization. Then we all will be able to overcome with this particular crisis. So what we have to look, we have to see whether whether United Nations has some provision or whether United Nations Charter speaks about cooperation. Let me, before I come to the charter, I just want to mention one important thing, and many of you are aware, that is related with the first time in the history of United Nations, the health issue was taken as a threat to international peace and security. So first time in the history of the United Nations, health issue was taken or discussed under the United Nations Chapter 7, we say threat to peace, breach of the peace, and act of aggression. So those who have some interest to do research or future related with the right to health. So what happened in the 2014? So much before this crisis, in 2014, you are in large number of countries in Africa, they were affected with the Ebola crisis. So Ebola crisis time in 2014, Security Council of the United Nations adopted a resolution, that is Security Council Resolution 2177, Security Council Resolution 2177, and said that the crisis has a propensity to disturb international peace and security. So what happened? The right to health issue was discussed under the Security Council under the broad umbrella of peace and security. So international peace and security. And that is why many people, many human rights scholars have criticized in the Security Council resolution, not a single time human rights, right to health as a human rights has been identified or discussed. But United Nations in 2014, they discussed the right to health under the peace and security umbrella, and they said it's a threat to peace and security, but did not recognize human rights. I have no problem, and I think many scholars have no problem. Whatever way they try to handle that particular crisis, it would have been nice, it would have been appropriate if Security Council would have, Security Council had taken note of the human rights normative framework as well, while recognize right to health as an international peace and security crisis. But we leave. So 2014, we have the first, and that is the first time Security Council has, after that, no resolution, again, right to health. So that was the first occasion. So we see some kind of positive development regarding addressing human health issues. Now come to the charter part. And when we go into the charter, where the charter talks about anywhere cooperation. Like, if you ask, like, Liberia, if you ask Somalia to take care of health issues, and that is not possible. So there is a, there is a need for cooperation. So what we see under the Article 1, Paragraph 3, which clearly says to achieve international cooperation. So says that there is a possibility to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character. So he said, achieve international cooperation in solving international problems of economic, social, cultural, or humanitarian character. And it goes further and it says, and in promoting and encouraging respect for human rights and fundamental freedoms for all without distinction as to race, sex, language, and religion. So Article 1.3, which is a part of the purposes of the United Nations Charter. Article 1.3 in number of places replicated in the 55, 56 and other provisions of the Charter. So Charter does talks about the international cooperation to solve problems of solving international problems. So this problem is international. So you can go for international cooperation is one of the purposes of the United Nations. And all members have to work together. And this can be clubbed under the humanitarian character. So it's a humanitarian crisis what we are facing. If I elaborate the presentation of Professor Ratan Singh, it's a humanitarian crisis. He gave in a dimension. It's a humanitarian crisis. It's not. It's a human rights. People are not concerned about Corona. They want to reach home. So humanitarian. So first they want to reach and then see what the positive or negative. First they dream they have how to reach home. So it's a humanitarian of huge proportionate. So this has to be addressed. So International United Nations Charter clearly states, and member states have to cooperate in solving the problem. So Charter is very much clear, international cooperation, and that is why Secretary General is making a statement. I hope that more proactive role will be played by the United Nations. And the another part of this Article 1.3, it talks about the promoting and encouraging respect for human rights and fundamental freedoms. So many people say Charter has not defined human rights, what fundamental freedom. It is more promotional. It said only promote. It doesn't use the term protect. It says promote and encourage is the state. Promote and encourage. It doesn't talk about the protection of human rights. So it deliberately left to the state to define and elaborate the human rights for various reasons, which we don't need to go right now. But however, for our purposes, we feel clearly Security Council Resolution 2177 and also Article 1, Paragraph 3, along with 55, 56 and other provisions, which emphasizes on the cooperation to resolve a problem of having international nature and humanitarian character. So this particular crisis desperately looks for the solution through the cooperation, and that is the charter. I end with the charter and I quickly go to because other two speakers are there. So now we go to the normative human rights framework. When we look into the normative human rights framework, there is an obligation of the state, whether human rights treaties, which talks about the right to health, And before I come to the International Human Rights Treaty, I see there are all treaties, including American Convention on that is like we have a scholar from the Canada. He will be so like uh, yes, San Salvador Protocol, which was added in, which deals with the economic, social, and cultural rights in the American Convention on Human Rights, San Salvador Protocol. They have a provision regarding the right to health. African Charter on Human and People's Rights has a provision for the right to health. Universal Declaration of Human Rights under Article 25, right to health. So various regional and under the European Social Charter, Article 11 of European Social Charter. So right to health directly. So that will be very interesting how Kevin is going to highlight about the jurisprudence of the European Court of Human Rights, because there is no right to health recognized under the European Convention on Human Rights. So I will hear from him. So there is no right under the European Convention on Human Rights. There is no right under the International Covenant on Civil and Political Rights talks about right to health. It talks about, so right to health is available into the economic, social, and cultural rights. So in Europe, it's a European Social Charter, that one instrument, and there are other instruments also. European Social Charter, which talks about the right to health, which is also applicable. So we'll hear that. So we see that various human rights instrument also speaks about the right to health. Coming to the our purpose today, I will just focus on the International Covenant on Economic, Social, and Cultural Rights. International Covenant on Economic, Social, and Cultural Rights, we try to understand on twofold. So we are looking into the International Covenant on Economic, Social, and Cultural Rights. For my foreign colleagues, just to inform, India has ratified that convention on 10th April 1979. We mean that it's a legally binding for the government of India to apply the right to health, that International Covenant on Economic, Social, and Cultural Rights at the domestic level. So the two part we'll try to see. The first we'll try to understand nature and obligations of the state. What kind of obligation it has under the International Covenant on Economic, Social, and Cultural Rights. And second stage will look into the right to health. So there are two articles which are important. For the first, for the nature and the scope of a state's obligation, that is Article 2, Paragraph 1 of the International Covenant on Economic, Social, and Cultural Rights. So Article 2, Paragraph 1, it clearly says each state party to present covenant undertakes to take steps. So you have taken an obligation that you are going to take steps individually. So individually, whatever capacity you have individually and through international assistance. So like individually and through international assistance and cooperation, through international assistance and cooperation, especially economic and technical, to the maximum of available resources with a view to achieving progressively the full realization of the rights mentioned. So International Covenant on Economic, Social, and Cultural Rights also realized the rights which are mentioned under this convention cannot be implemented by state itself. So state can seek cooperation from the international assistance and cooperation, but and progressively implement. So it also talks about, so what we have located in the charter, that Article 2, Paragraph 1, it puts responsibility on the state, but the state can seek cooperation from the through international organization or in states also regarding the implementation. And it says progressive realization. So it's a positive right, progressive realization of the human right. Quickly to come to the 12, that is Article 12.1, which talks about right to health. And what Article 12 says, the state parties to the present covenant recognize the right of everyone to the enjoyment of the highest attainable standard. So it's not only right to it, it's the highest attainable standard of physical and mental health, highest attainable standard of physical uh, highest attainable standard of physical and mental health. So the very higher threshold has been fixed. It's not an ordinary. So you have a very sufficient, high quality of medical facilities for your people. But what we have and what many states have, that is the question which we have to find out answer. So that is the broad obligation, huge obligation under the Article 12 for these states. So government of India has an obligation, and also number of the neighboring countries regarding the highest attainable standard of physical. Now the third, 12C, in the pandemic or epidemic, we have to see. The state has an obligation to prevent. So like, somehow prevention was not possible, now we enter. Once you fail in the prevention, then treatment and control of epidemic. So the state has an obligation under 12 paragraph 12C, which says prevention, treatment, and control of epidemic, endemic, occupational, and other diseases. So what we see, the human rights normative, when we have looked only on one human rights convention, what we have seen that broad obligation is there. And of course, for realization of these rights depends upon the resources, program, policies, a lot of factors are there. But just to quickly to sum up, I see there are sufficient laws which helps a state, which is going to help a state to seek international assistance, or international agencies also have an obligation to help the state to overcome. We will only be able to overcome this particular crisis when we work, when we are united, when we work as a citizen of the world, when we work as a global citizen. And even if vaccine comes, a vaccine is very expensive, then it will help only the rich people. So that has to be very nominal price. So a lot of factors which are in future will also play very important role. In case of development of vaccine has to be affordable. So each poor people can afford and go and take vaccine to keep himself free from the future future crisis of coronavirus. I think with this, I just want to say a few words that of course, right to health is a human right in the national law, regional law, or international law, and the state has an obligation to ensure the rights of it's a citizen must be respected in all time. And I hope that that goal will be achieved soon by the each state. Not I'm talking about each state, and we all will be free. Lockdown will be over, and we can walk free. We can meet freely, and we enjoy our life. Thank you very much.
Thank you so much, Professor Sinha. I think the best takeaway from your speech has been about international cooperation, which is the need of the moment and which will be the requirement to come out of this time. I would participants that we would ending the time by 10 minutes. So this will go on till 7:10 because we have two more people, and then I will also touch a little bit of the Indian aspect. So I will now request Dr. Kevin W. Gray to please take over and share his thoughts and presentation on.
All right, thank you, Dr. Bedi. I hope you can all hear me. If you can you nod? All right, good. So I'm seeing Sebastian nod. And also, can you tell me if you can see the screen? All right, perfect. So what I want to talk about, I'm going to try to tie this into Professor Sinha's interesting comments, is to what extent are what are the rights protection obligations under the European Convention on Human Rights? And importantly, how would states derogate from those obligations in times of emergency? So those of you who don't know, the European Convention on Human Rights actually predates the ICCPR. If you're not familiar with it, the actual rights protected by the European Convention are very similar to those protected by the ICCPR. The key distinguishing feature between the two is the fact that we have the European Courts of Human Rights, which adds some degree of justiciability to the rights protected by the convention. And I noticed that in one of the questions, to what extent is there a remedy provided for violations of the convention by states? I should just note in passing that the European Court of Human Rights actually tends to be rather slow, so we don't have any case law yet. To give you an example, a recent study found that if there were no more cases added to the docket of the European Court, that is the Strasbourg Court, it would still take 7 years to clear the backlog. So we're unlikely to have any major rulings on COVID and the European Convention anytime soon, even though the court tends to give priority to these sorts of urgent, large-scale questions. I should also note, just in passing, and this is just for those who aren't familiar, the European Court of Human Rights is not a part of the European Union. There's actually the Court of the European Union is the European Court of Justice. People do sometimes confuse them, but it is worth noting that every EU member state is a party to the European Convention on Human Rights, but the converse is not true. So states like Russia and Turkey are parties to the European Convention. So convention rights generally, the convention generally protects things, like I stated on the previous page, like the right to life, the right to security of the person, prohibitions against torture, right to free speech, right to assembly, standard sort of first generation human rights. And Professor Sinha was correct to note that it doesn't contain a right to health. I will just sort of put that in brackets temporarily, because there's a way in which the right to health has been partially read into the convention, but it's an obligation of progressive realization, and it would actually be rather hard to violate. But in a time of emergency, the convention provides that states can derogate. And they can derogate where there is either a time of emergency or a time of war, provided that they can justify that derogation and any measures taken on a strict proportionality analysis. So much like the Oakes test in Canada, which Sebastian's going to discuss in his lecture, states can derogate provided that it is necessary to meet some urgent requirement. You cannot derogate with respect to certain articles, however, or with certain protections, and I'll discuss those further. And procedurally, when you derogate, you must inform the Secretary General of the Council of Europe why you are derogating and with respect to what rights. So, just quickly, you cannot derogate from the right to life generally, except during times of war. I should note that there is a positive right to life under the convention, but it's unlikely. So a number of states have derogated with respect to the COVID-19 health crisis. I'm not going to go through their particular derogations, but generally they have derogated from the right to assembly, the right to movement, and the prohibition on unlawful confinement. Interestingly enough, if you notice the list of states here, it doesn't include Germany, France, or Italy, as those states have felt that within the framework itself, derogation was unnecessary for them to meet their, to meet whatever they were required to do at the domestic level to fight COVID. But a number of states have derogated. They've relied on Article 15 and informed the Secretary General of the Council of Europe of their decision to derogate. So if a state is going to derogate, and I'm going to go through these one by one, obviously there must be a state of emergency. This derogation must be strictly proportional. It may not violate other obligations under international law, and you must inform the Secretary General. All right, so there's no jurisprudence on whether or not COVID constitutes an emergency under the ECTHR, and it's unlikely there will be any. As far as I know, there's actually no jurisprudence more broadly on whether such a pandemic could constitute an emergency under Article 15 at the ECTHR. The relevant case is Lawless versus Ireland, which is actually a case involving the IRA and sort of terrorism in Northern Ireland more broadly. But an emergency is just an exceptional situation of crisis or emergency which affects the whole population, constitutes a threat to the organized life of the community. It seems likely, and I think this is the general view of most commentators on the convention, not just myself, that COVID will meet that threshold. I mean, I think the first prong threshold here is actually rather minimal. Most of the action is going to occur at stage 2, whether or not the derogation is strictly speaking necessary. And there'll be actually at this stage very limited deference to the state. The state will be required to show that any actions it takes are strictly speaking necessary and proportionate in a balance between the rights of the individual affected and the needs of society. Importantly, the derogation can't violate another obligation. So for instance, you cannot derogate from the European Convention and not derogate from your ICCPR obligations, or if you do, you must derogate. If you are going to violate the ICCPR, you must derogate as well. That is perhaps not that interesting because the obligations are so similar. States are likely to derogate in parallel, and in fact, many have done that. The interesting question, though, are the various conventions on the protections of women, children, and the disabled, and whether or not these derogations potentially violate those conventions. This has not yet been litigated, and it's hard to know what to say about this, other than that states have so far been cautious to derogate from conventions equally. And then when a state derogates, it must give very specific formal notification and clearly specify the restrictions it will put in place. So potentially derogations have occurred with respect to a number of articles, and then in the remaining, I think I have about 8 minutes left. I want to go through what these articles are. So there's a positive right to liberty and security. We know that strict house arrest falls within the definition of a deprivation of liberty under Article 5 and may require derogation to be lawful. However, there are key distinctions here. So if you look at the United Kingdom, so the UK, of course, is still a party to the European Convention, even if it's no longer part of the EU. If you look at Article 5, a requirement that one stays within a specific distance from one's house is probably not a violation of Article 5. We also know that there's no need to derogate from Article 5 for the purpose of detaining infected persons, provided that that derogation is limited in time and serves a clear purpose. The threshold is rather high, and we have no jurisprudence to suggest that healthy persons could be covered by Article 5, as in the United Kingdom. So it's almost certainly the case that if a state wants to invoke a stay-at-home order, it must derogate from Article 5. Conversely, though, it's likely that the UK's limited travel restrictions probably are not covered by Article 5. I'm quite happy, by the way, I should say at this point, that if the organizers wish to share these slides, they can. I've put in some, additional citations to some of the most current discussion if people want to look it up themselves. There is, of course, a right to privacy protected by the convention, and there's no doubt from the previous jurisprudence that collecting of bulk medical data, including international travel, health data, by the authorities would violate the right to privacy, subject to the implicit limitation in Article 8 that the collection of such data is permitted if it can be shown necessary to protect the health of citizens. It's worth noting that states do have a limited positive obligation to protect the health of their citizens under Article 2. So it's likely to be the case that the bulk collection of data will be permitted under Article 8, at least with respect to the question of COVID infections. And I think what's quite likely to happen here is that Article 8 jurisprudence is going to substantially develop over the course of the COVID crisis. And in many ways, we may see an increased winnowing of the protections afforded by Article 8 under the name of protecting the health of citizens under Article 2. So in many ways, I think what we're going to see during the crisis more broadly, and I think some of the earlier speakers alluded to this, is a way in which the tension between rights leads states to then be able to roll back rights protections. Now, Articles 9 and Article 11, sorry, the slide is mistitled. It should say Articles 9 and 11, but Articles 9 and 11 provide for freedom of religion and association. Clearly, states have banned public gatherings and religious services to prevent the spread of the virus. And the question here is going to be a proportionality analysis. And more importantly, how the evenness under which these prohibitions are invoked. So if they're directed at stopping the spread of the virus and applied uniformly, they're likely to be found lawful. However, in some cases, we have seen them used to silence critics or the opposition, as in Hungary in its recently enacted emergency laws. Those will likely be found to be pretextual and a violation of the European Convention. I can recommend Kim Lane Sheplay's recent articles on the Hungarian situation for those who are interested. And finally, there is an additional protocol, Protocol 4, Article 2, that provides for freedom of movement within the territory. There's no doubt that lockdowns would implicate Protocol 4 rights. Protocol 4, though, is generally thought to be less to be a less rigid right than other mobility rights provided under the convention itself. Yeah, so what I wanted to do is conclude with Italy as a case study to give people some example of how this might play out. It's worth noting, if you refer back to my previous slide, that in fact, Italy did not derogate from European Convention rights. So it cannot avail itself of Article 15. So Italy has enacted a number of provisions, which I think we've all seen. There've been movement limitations. Individuals can only leave their house for work, situation of necessity, health reasons, or to return home, obviously. Quarantine and isolation, which has meant quarantining individuals who might have been exposed, isolating people who have COVID, lockdowns to limit public gatherings, only allowing limited openings of stores, and limiting openings of bars and restaurants more broadly. Now, it's pretty clear that these are going to violate a number of convention protocols, but the one I want to focus on is Protocol 4, Article 2. We know generally that restrictions rather than deprivations under the European Convention are subject to less severe scrutiny. So a 24-hour curfew would be a deprivation, whereas a 12-hour daily weekday curfew would not be. And therefore, the 24-hour curfew would be covered by the convention itself, whereas the 12-hour convention would be covered by the protocol, and thus the separate jurisprudence. Now, I think there's some disagreement among commentators how to classify Italy's restrictions. There are some exceptions to the restrictions. People are allowed out, and therefore they seem closer to Protocol 4 Article 2 restrictions rather than convention restrictions itself. And more importantly, I think the general view is that the lockdown restrictions are probably better analyzed under other rights restrictions, that is Article 9 and Article 11, and that's separate jurisprudence. But there's going to be a number of key outstanding questions that are going to remain, and we simply don't have jurisprudence on this. So all I'm trying to do at this point is broadly sketch out the framework under which the court's going to have to work within. So the first key question in any European-style proportionality analysis is whether or not the lockdown serves a legitimate government purpose. And I think given previous rulings, it likely does. However, there's two procedural components that are going to matter. There's a lack of due process. So for instance, can people challenge these restrictions? And that looks like it may lead to arbitrary detention in violation of the convention. And there's also the procedural safeguard that people must be informed of why they are detained in the language in which they speak, in a manner which is understandable to them. And so a lot of this is going to depend on how effectively the government communicates the new rules to individuals. I would commend the recent writings by several UK public scholars on this question as to whether or not the recent British relaxation of restrictions violate the rule of law by being impermissibly vague. So under this second test, there is a key question as to whether or not the restrictions themselves are void for vagueness, at least in some contexts. But broadly speaking, that is the jurisprudential framework in which the European Convention and the European Court of Human Rights will analyze the restrictions. And with that, I pass the floor back to Dr. Bedi. Thank you so much.
Thank you so much, Dr. Kevin. This has been an amazing and a short and a succinct analysis of the rights under contention. And you rightly point out that it is the due process of law which we need to really look out for during these times. And the derogations which are happening, yes, it is a health crisis, but like I said, it is more of a human rights crisis now. So without further ado, I would now like to request our next speaker, Sebastian Lafrance, the Public Prosecutor Council at Canada, to share his thoughts about what is the impact on the rights in Canada.
Thank you very much, Professor Bedi. I will do as Kevin. I do have a PowerPoint presentation. So if you don't mind, just to nod if you can see my presentation PowerPoint. Yes, fantastic. Yeah. Several things, and my presentation may be a bit shorter because several things have been already raised by the great and honorable previous speakers. So what I would like to give you is more perspective directly from Canadian law, and more particularly from the Canadian constitutional law and the fundamental rights protected by the Charter. So there's what I found interesting very quickly is the mention of the importance of the world crisis that we're in really early in the days by the courts in various cases. It impacted not only fundamental rights, but also various aspects of the law. And this is a slide I will not comment it further, but that's a nice description of what is currently going on. And as we all know, there's the main difference between COVID and the various previous issues and epidemic before is that this time this is a pandemic. So we are in a complete different ballgame, if I may say. And there, of course, there are impacts, as we have seen with the previous speakers. There are impacts on fundamental rights. And there is something that is very interesting, and you will see on this slide, this is an article published in the Yale Law Journal, but published in 2003, so 17 years ago, where the challenge to fundamental rights was already identified at the times of crisis. So it clearly says, the second quote, that at times of crisis, it does pose the greatest and most serious danger to constitutional freedoms and principles. So we'll see a few of those challenges today in the context of the Canadian Charter of Rights and Freedoms. So here you find the Hindi version of the Charter of Rights and Freedom from Canada. And we'll see a few examples, practical examples that may overlap with a few examples raised by Dr. Gray. However, the examples I will discuss are more specifically in the Canadian context. To give you some background very quickly, the Charter of Rights and Freedoms was adopted in 1982. It doesn't mean that before Canada didn't have a legal instrument protecting fundamental rights and freedoms. However, the previous legal instrument, the Canadian Bill of Rights, didn't have the scope and the importance in terms of a large and generous interpretation as the current Charter of Rights and Freedoms provide in Canada. The first example I will discuss, and that was raised by Dr. Gray at the end of his presentation, is the impact of COVID on the freedom of association. For example, very practically, the government of one of the provinces of Quebec was one of the first ones to basically stop and prevent people from gathering together inside and outside their homes, basically isolating people in their house as early as of March 2020. So of course it does ask the question of the freedom of association. Can people, not only in the context of demonstrations, of expressing their dissatisfaction with their employers, with the government, etc., but also touches directly to the possibility of people, family members, for example, to get together. There's a few exceptions, obviously, to this to this prevention of people getting together, which is the essential workers. But even that notion of essential workers fluctuated pretty much, and the meaning of it, the definition given to it, pretty much changed based on which province we're talking about and at what level. So you have to know that just as a very brief constitutional basis, the health issues in Canada are mainly addressed by the provincial levels, by the provinces. There are 10 provinces in Canada and 3 territories. The territories are under federal jurisdiction, but the provinces do have jurisdiction to decide what they will do with health issues. Of course, the government, because of the consequences of COVID-19 on public order and good governance, for example, still have a say in what is done, but they cannot interfere directly unless they, and we'll touch upon this, unless they rely on The example is the Emergencies Act, which is exceptional and which has not been relied upon by the Prime Minister of Canada, Justin Trudeau, so far. Another example of one of the impacts of COVID-19 on the constitutional rights for citizens of Canada is the freedom of movement. So basically the right to move inside the territory to wherever you want and also to leave the country as you wish. What I found interesting here is the Supreme Court of Canada in DeVito in 2013, not so oft-cited decision so far, but of course nowadays that things have changed fundamentally, I expect that this decision will be mentioned, will be referred to, and will be cited way more often. So Section 6 of the Charter of Rights protect the freedom of movement, but now that everybody, not only in Canada, but on the planet, have their movements somehow restricted to various extents, depending on the country, there's this right that is affected. For example, practically between provinces, there were checkpoints, like Checkpoint Charlie in Berlin. Of course, they're not held by the militaries. It is not an international border. However, and this is one of many examples, police officers were stopping people trying to leave Ontario or vice versa to go to Quebec and or to go back to Ontario. So basically, and there were even also checkpoints inside the provinces, for example, in the province of Quebec, to stop people from moving to one area to another within the provinces. Where we are not going to discuss the jurisdictional issue here, but I just wanted to give you the example of movement being restricted and the potential breach that is incurred. I must say, I forgot to say it very quickly, that everything that I'm saying now is not binding on the Public Prosecution Service of Canada. I'm just speaking to you very happily today on my own behalf. So let's move on to, and that's something that was raised before, namely, for example, by Dr. Gray regarding the right to be searched, basically a right to be searched and unreasonable searches and seizures. So this is protected by Section 8 of the Charter. And the best example here, and that's why I put this picture, is that the state had the idea, and that caused a turmoil in Quebec, for example, in other provinces, to basically follow people who are being diagnosed with COVID-19. So basically, when you're diagnosed with COVID-19, we'll do something in your cell phone, whatever, and we'll make sure that you're not going out and contaminate other people. So that measure was not implemented, but it was discussed and raised, and of course it was heavily criticized. Section 8, as I recall, as I've seen, has not been directly addressed, but obviously that speaks directly to unreasonable search and possibly of phone data that would say where people are staying, if they're staying home as they're told to do. So basically, again, Section 8 and Section 6 that we have seen, the restriction of movement, are somehow overlapping in terms of potential breaches caused by COVID-19 in Canada. The last right, fundamental right protected by the Charter of Rights and Freedom that I would like to mention is the impact on the trials, namely the criminal trials in Canada, to be tried within a reasonable time. And that's a fundamental right in Canada. So the Supreme Court of Canada established basically ceilings, one of 18 months for cases that go to the lower courts and 30 months for cases that go to the Superior Court. So basically COVID-19, because it delays, many courts have simply shut down and only allow appearances by phone for urgent matters. And here I oversimplify things. It's more complicated than that, but still you have to know that there is a clear impact on the court system, which in turn is basically has an impact on the delays of the hearings. However, the argument, I would say very respectfully and on my own behalf, that you can look at the quote here, the second one, there can be no more unexpected and exceptional event than a global pandemic. That's been discussed as well by Dr. Gray. So it is not very much expected. Maybe some defense counsel will raise this argument based on the fundamental right to be tried within a reasonable time. But it is more than likely, in my opinion, that the delay will not impact greatly on the trials themselves. That will delay them for sure, but a successful argument based on the breach of not having been tried within a reasonable time is likely to not be that successful, in my opinion, based on that quote. So basically, there's the Emergency Measures Act that exists. This is an exceptional law that exists in Canada upon which the government may rely to bypass the fundamental rights. And of course, this is something that is very exceptional and not done usually. If the government does so, the government still has to establish that it does comply with Section 1, the Oakes test that the other speaker, Dr. Gray, mentioned. So Section 1, the Oakes test, it still has to be justified in a free and democratic society. So this is the slide here. So any measure taken by the government that would breach, if the government would rely on the Emergencies Act, has to comply still with the umbrella that goes over all the rights. So the second, that there's a two-step. So if there is a breach that is acknowledged by the courts, and then the court must turn its minds to if the breach itself may be justified in a free and democratic society. Also, the government, but just as a side comment here, there's also a notwithstanding clause. This clause allows the government to basically suspend fundamental rights. It hasn't been used in the context of COVID-19, but interestingly, as pointed out by one of my former clerks at the Supreme Court of Canada, who's a professor of law now, of constitutional law, basically he wrote this and he said, well, that's surprising that the government did not rely on that clause, the provincial governments, for example, where they relied on it to suspend fundamental rights in a different context, not COVID. So they basically said, we will not subject ourselves to the application of fundamental rights. We will bypass it by relying on Section 33. And when they do so, they do have to in the legislation, they have to state it clearly that they do derogate to the fundamental rights, and they can do so for a period of 5 years, which can be renewed. So to wrap up this presentation, I found that this wise words, this famously known, those who try to not give up, this poem basically in India is very interesting. So when it says, Koshish karne valuki har nahi huti, asaphalta ik chunoti hai swikar karu, gyaka mire gei daku or sudar karu, jab tak na sabhal ho, dijan kotyagutum, sanghash kamedan chur matbe hagutum. So I found it very inspiring. Of course, I apologize for my severe and strong accent in Hindi. I just started learning it 2 months ago, but I really wanted to, basically this delivers a message of courage. Basically in English, it says that the failure shouldn't be accepted. Do not run away from the battlefield at the end. That's the last sentence of this famous and beautiful poem. So I would like to tell everybody to not run away from the battlefield in the fight against COVID-19. Hang on and be brave, and we'll go through it all together with our brains, our minds, our soul, and our heart. Thank you very much.
Thank you so much, Sebastian. That was a beautiful ending, and I'm sure your Hindi accent didn't take away the message that you wanted to deliver. So we will not, if I may say so in Hindi, hum maidan chhod ke nahi bhagenge, as you say. So One more point which has been raised by Sebastian, which also must be raised in India, is the right to a speedy trial, which I think right now nobody is talking about, because there are too many other far more important issues which are coming up before the courts. And that's where I would like to take my part, a short summary of a couple of things that I want to focus on with respect to the impact on the rights in India, because we don't have so much time to cover all the rights. But one point which we have seen is that recently the Supreme Court and the High Courts have seen a flurry of petitions regarding the violation of various social and economic rights of the citizens, or rather, if I may say so, the most vulnerable section of the population. And these rights have been spoken about all our panelists today, Professor Ratan, Professor Manoj, Dr. Kevin Gray, Sebastian. But I want to focus on the fact that these socio-economic rights that we are talking about are pertaining to include the right to health, the right to wages of the poor people, of the migrant workers in India, who we are really concerned about at the moment, the food security, the right to food, because people are not getting food, as Professor Ratan Singh pointed in the beginning, the right to livelihood, which was highlighted by Professor Manoj Sinha. So these are few rights, but the point being that these are not rights which have been textualized in the Constitution of India. They are mentioned as the directive principles of state policy, but have only been incorporated into the Constitution through judicial interpretation, which means that their meaning, scope, and reason and legitimacy is only to be decided by the courts and not by the Constitution of India. So they do not have the constitutional backing in the written word of black and white as fundamental rights as such. It is through the interpretation given to the directive principles that and through an expansive interpretation of Article 21, right to life and liberty, which Dr. Kevin Gray was also talking about in the context of the European nations, that the expanse has been included to cover these rights. So what is happening is that you see the Supreme Court, especially in India, showing a policy of deference towards the executive. Now they say that, it is common knowledge that the judiciary does not interfere in the working of the executive, especially the policy decisions of the executive. However, I would like to point out here that intervention would be required if the policy decisions violate the fundamental rights. Now, these rights which I've spoken about, the right to health, livelihood, food, wages, etc., these are not fundamental rights, but they have been interpreted to be so. And therefore, this is where we find that there is a lack of a standard of review present in the interpretation of the judiciary. Because of this shifting standard, which is not based on any one firm policy, we see that there is an up and down interpretation in the judiciary, the courts. If you see one court or a bench of the Supreme Court which would consider right to health, which was spoken about by Professor Manoj Sinha and Dr. Gray, being given more importance, and the other bench of the same court not taking it to the same level as that importance of the right to health. So it is this shifting standard which is often employed by the different benches of the same court or by the different courts, that is where we find that which leads to the deference of the executive policy. And here I would like to point out two examples. One is the case of 1996 of Paschim Banga Khet Mazdoor Samiti, where the Supreme Court said that financial constraint is a constitutionally unacceptable reason to deny the right to health care. So even if the state says that we don't have the money, that is not acceptable, because the right to health is so important that they have to do anything to make it possible for the people. As opposed to this, if you see the recent order of the Supreme Court of India on free testing, of people who are suspected of COVID-19, free testing only being now made available to those people who cannot afford it, the court did not engage with the responsibility of the state towards the universal right and scope of the right vis-a-vis the right of health vis-a-vis the financial constraints. So they are taking the convenient position out, and they are not really analyzing the law at this point of time. So the shifting scale of the decisions and the judicial precedent allows them this kind of a flip-flop. One more point that I would like to point out today is with respect to what Dr. Gray has highlighted, and that is the right to privacy. An aspect of right to privacy is the right to be forgotten. And in this context, I want to bring up an application which the government of India has asked the people to upload on their phones, which is called Arogya Setu, and which requires the name, sex, medical antecedents of all the people. It has been, through government orders, it has been made mandatory for all private and public sector employees. In fact, the Noida police recently had gone to the extent of saying that it will be a criminal offense if you do not have this application on your phone. Now, the concern is with respect to right to privacy, which has been laid down as a fundamental right in the 2017 judgment of the Indian Supreme Court in the Puttaswamy case. Now, this Arogya Setu app uses the Bluetooth and the GPS services, through which it is able to convey which person might be COVID positive and where do you need to safeguard yourself. A laudable objective, but what is happening? Now, the information which is updated periodically is uploaded onto the app as well as the server. Now, if you do not test positive or if you do not show the symptoms of COVID, the data is supposed to be deleted as per the app, the policy of the app, in 30 days. If you show some other symptoms which do not result in a COVID positive test, it will be deleted in 45 days. And if you have COVID and if you have now been cleared by the medical authorities, then the data is to be deleted within 60 days. But the important point to be noted here, which I want to highlight, is that the data is not deleted from the app. It remains on the app. Despite the fact that it is deleted from the server, the application continues to possess that data, which could be misused. And this is contrary to the aspect of the right to be forgotten. And here I would like to point out a case of the European Court of Justice, which is popularly known as the Google Spain case of 2014, where a case was filed by a Spanish citizen against Google, requesting Google to delete the links which concerned his, they portrayed him in a negative light about his debts which had amounted to, and his that the certain properties that he owed to other people, and the financial hardships that he was going through. So the Court of Justice of the European Union ruled in his favor, and acknowledging that everybody has a right to be forgotten, and that his privacy was being violated by not deleting this information from the internet on Google in this manner. So if an information has become irrelevant or inadequate, a person has a legitimate right to get such data removed. And this is the right to be forgotten from the internet. Now, if you look at India, we did not have any particular law till 2011, which was the IT information technology rules which came up, which again did not talk about the right to be forgotten. And it is only through the Puttaswamy judgment of 2017, which has recognized the right to privacy, and Justice Kaul, while interpreting Article 21, says that this right to privacy includes the right to be forgotten. He in fact says that if an individual desires to remove his or her personal data from the virtual space, it should be respected. And if the information, especially if the information serves no legitimate interest or was incorrect or was not necessary. So if you look at it, the right to be forgotten is founded on the dignity of the individual. And if you look at the Arogya Setu app, the personal data which is uploaded is by the users of the app is supposed to be only for a specific purpose. And if that is to ascertain the health status, and once that specific purpose is over, the entire data, the entire personal information of the person should be deleted, which means that he has a right to be forgotten. In fact, what it says is the outcome of this is that the right to be forgotten is grounded in the fact that a citizen has control over his or her digital footprint, and then thus no competing claims can be made for or his information or his personal data whatsoever. So these are a couple of issues which I wanted to highlight. The time is short, and therefore I will not take more time, but would like to first of all, thank the panelists for the extremely interesting and pertinent issues that they have raised and also explained during the course of this panel discussion. I would also like to thank our participants who have been quite active. We have Dr. Jasneet Palia, who is a colleague at the University Institute of Legal Studies with us, Shikha Dhiman, Seetal Sharma, Dr. Bhupinder from the Army Institute of Law as well. There are so many students who are here. Arpit Malhotra has been so kind to give us the technical support. And there are so many questions. So I'm just going to take up a few of them because we are already past the time of 7 p.m. But we can take a couple of questions. One is from Rangat Ghira. He says, are courts functional in Canada and England? Is legal profession considered an essential service there, unlike India? I would request Dr. Kevin Gray if you could answer this, or Sebastian.
I mean, I actually haven't looked most recently at the UK regulations, but they are functioning minimally for important and urgent matters. Most trials were suspended at one point, but urgent matters are being heard in both countries. Sebastian, I know, can talk in more detail, but I know that bail hearings and other detention hearings are continuing in Canada as well.
That's accurate. And also there were a few trials held online, but these are very exceptional, basically, because of course you cannot file any exhibits. There are some limitations to having trials online.
So, you know, if you want to go commit a crime in the UK and it's relatively minor, it's like, but so generally speaking, there's been a movement to limit. I notice that people are touching their ears. Can they hear me? I generally know.
It's all right.
Yes,
The voice just went off a bit.
Okay. Yeah. So generally, there's been ways in which courts and police have been pragmatic in both countries about reducing level of charging and trying to eliminate incarceration. In fact, it's one of the few positive things that may come out of this would be a reform of the court system that will see fewer people incarcerated on low level offenses.
Thank you, Dr. Gray and Mr. Sebastian Lafrance. Another question to the two of you, I think, or maybe Professor Sinha, from Nischal. He says, can a lawsuit be filed against China? Many countries like the Five Eye Group accuse China for purportedly destroying the evidence of the coronavirus outbreak that left millions affected.
Okay, so I'll guess. Do you want me to start with this,
Sure,
or
sure, go ahead.
do you want to go? Okay. Very quickly. I mean, I would actually. There's a really great article that was just published by Peter Tseng, who has been representing Qatar before the ICJ. Before that, I think it's on EGL Talk. But if you just Google his last name, Tzang, he's got a really great discussion of it. The problem is not so much whether or not you can file a lawsuit against China in the sense of whether or not China might have violated a substantive obligation. It's whether or not there's any court that has jurisdiction. And so the question is whether or not any of the relevant WHO or international health treaties confer compulsory jurisdiction on ICJ. And I think it's less than clear, let's put it to you that way, that they obviously you're not going to get Chinese consent to have this indicated.
Thank you, Dr. Gray. Rahul Sangwan is saying that, can we address the question that Professor Ratan Singh, I think he is addressing this to you. He says that how the judiciary in these times has become the watchdog of the government policies instead of watchdog of the constitution. That we should trust the government and abdicate, by saying the judiciary says that we should trust the government and abdicate their own responsibility. Like Professor Ratan Sir said, that Supreme Court said in case of migrants, they can't track their movement.
Yeah, Rahul, just see the two issues are there. Once we are talking about our judiciary is the watchdog of the constitution. But on the other side, every action which is to be taken by the government, that certainly under the provisions of the constitution, they cannot bypass constitution. So ultimately, everything falls under constitution, and the judiciary is to protect the constitution, and they are the watchdog. You know, the second issue, as far as the directions of the Supreme Court are concerned, you know, this is an issue of interpretations. In some of the matters, the Supreme Court take it's a very urgent, but in some of the matters where it may be urgent, but Supreme Court never consider it as urgent. So probably, as already said, there are many implicities in our constitution and in the laws as far as the interpretations are concerned. No, it all depends on the government, on the Supreme Court, to take the matter in a very serious note, or maybe they have their own compulsions, or maybe quite possible the situation under these days is so tough that government is not handling, and Supreme Court is rather supporting to the government while taking such of the decisions that what we can do and what we can do. So I suppose still this Supreme Court is a watchdog of the constitution, and everything is to be done within the provisions of the constitution.
Thank
Yes,
you,
Rahul.
Professor
Yeah,
Ratan.
please.
Professor Manoj Sinha, would you like to add something to that about the comment about the judiciary now becoming the watchdog of the government?
I think I agree what Professor Ratan Singh has mentioned, but I feel like, in the beginning of one of the matter which came before the Supreme Court of India also, where court, I think some court had said money, man, and materials are with the state. The 3M are with the state. So let the state, this is the occasion we have been, what you have also pointed out. It's sometimes we see who are there in the court. So it varies from the individual judges to judges. So even the interpretation of the Indian Constitution, application of fundamental rights, widening of directive principle under the fundamental rights, it depends upon the judges centric, I feel. And at this particular moment where it's good also in one sense, every is even if judiciary say right to food is a fundamental right, but ultimately it falls into the domain of executive to implement. There is a problem. Judiciary should more pinpoint on the implementation aspect instead of elaborating what it has to be. So we have in this current crisis which happened, the migrant workers are working. Court should have entertained. Court should have they said we can't monitor, we can't. Court should have said the government should issue some direction that could have facilitated. So I feel, I don't know what are the reasons, but there's just some kind of judicial restraint. What I am observing, judiciary is a little bit restraining from going to active mode to more looking into the black and white what constitution says. So like not watched too much like also becoming judicial activism, that is also creating a problem. So we have to see how court can play an important role in ensuring the implementation, a direction from the court regarding migrant workers must be facilitated all the facilities to reach their destination, that and you report us in 1 month. Things should have been different. I know in Indian system it works very well.
Thank you, Professor Sinha. I think that's about it. And we come to the end of our extreme inputs and insights into the impact across the world on the fundamental rights due to this COVID-19. I thank Professor Manoj Kumar Sinha, whose thoughtful inputs have brought us and highlighted the aspects in the international arena and have also given us food for thought about what it is, what will happen if we do not cooperate internationally with each other. Professor Ratan Singh highlighted many practical cases that India is going through, which we need to look at and really, think from the mind of the poor and the vulnerable section of the population. What is it that is required on our behalf? What is it that we need to do? Dr. Gray, you were brilliant in your exposition of briefly summing up all the rights impacted, and considering the fact that you were able to talk about the derogation rule under the European Court of Human Rights and how various countries which have derogated during this time of COVID, how are they functioning, and highlighted the case with respect to Italy. And of course, in the end, a very important part of it being that the worst thing under attack today is the due process of law. Sebastian Lafrance, another wonderful and fabulous talk by you about the rights under contention in Canada, including the right of association, the right to movement, and the right to trial. Given the fact that Canada is one of the better placed countries fighting COVID during this time, as compared to other countries, if I may say so. And the notwithstanding clause which the Canadian Constitution has in it is a very interesting study, especially from a point of view of the Indian Constitution, which does not permit such a kind of a step. So thank you all so very much for being here today and for making it so interesting. And it is great that the Punjab University 5-year law University Institute of Legal Studies has been able to host a panel of speakers who have spoken about such a variety of about the same aspect, but from a different thought process across the world, from Canada, Europe, internationally, and India. So thank you all very much for being here. The participants, the audience, you're the reason that we are here for you. And without you, it doesn't mean a thing. So thank you all for being here. And I wish you a very good night from India.
Dr. Professor Shruti, let's thank to Dr. Sophia Ahmed. She's from Dr. B.R. Ambedkar Central University, Lucknow. She has joined us. So thanks to Dr. Sophia Ahmed too also.
Thank you. I learned a great deal actually about the Indian constitutional order, and so I enjoyed that.